We'd like to start this session. The Administrative Enforcement Against Counterfeit Products. It's a panel discussion. I introduce the panelists. We have Mr. Hoshino Shintaro from the Japan Patent Office. From Cambodia, we have Phnom Penh Court of First Instance Deputy Prosecutor Ms. Song Shovon. From Laos, IP Dispute Resolution Division, Department of IP, Ministry of Industry and Commerce, Ms. Sulina Sisomunik. From Thailand, Department of IP, Ministry of Commerce, we have Ms. Rungron Bunyantrampum. From Vietnam, Ministry of Science and Technology, we have Nguyen Nhu Quinn. As commentator, we have from Kurose IP Management, Mr. Kurose Masashi. And as a moderator, we have from International Cooperation Department, Research and Training Institute, Ministry of Justice, Mr. Kuroki Kota. So they will hold a panel discussion. From here, I ask Mr. Kuroki to moderate, please.
Good afternoon, everyone. My name is Kota Kuroki. I am a judge in Japan, but currently working as a professor at the International Cooperation Department of the Research and Training Institute of the Ministry of Justice of Japan, which is providing legal technical assistance to Asian countries. I will be a moderator of this working session. This session is about administrative enforcement action against infringing and counterfeit products. Next slide, please. Let me briefly introduce about our schedule today. For the first 10 minutes, I, as the moderator, will explain about time schedule, case and questions, and make a little comparison of answers between countries. For about 75 minutes, we will have panel discussion with panelists from 5 countries: Cambodia, Japan, Laos, Thailand, and Vietnam. Each panelist will briefly make a presentation about the measures taken by their respective countries against counterfeiting goods within 10 minutes each. It may include answers to the case and questions, but it doesn't necessarily include all answers because it is difficult for them to make it within 10 minutes. So we let panelists decide what they want to emphasize or what they want to talk about at the symposium here. Every time after each presentation, the commentator, Mr. Kurose, patent attorney with a lot of experience in counterfeiting in ASEAN countries, will make some short comments within 3 to 5 minutes. Also, please allow me to say rubber please when the presentation time is over. Next slide, please. This is a case we already uploaded on the website. We are going to see how the right holder can solve the case with counterfeiting from the contact to a certain organization. The right holder company A has the trademark for clothes as designated goods in your country. As you can see the image earlier, many t-shirts made by company A have the trademark on the left chest. Company A happened to find company B's goods, or which are counterfeiting goods. Counter B's Mark 1 is exact same one to the trademark earlier. Company B's Mark 2, Alim, is similar one to the trademark. We prepared 2 marks so that we can know how it works and proceeds, especially with similar marks to the trademark. Regarding the paragraph 3, our employee of company A was surfing the internet and found that company B's goods were being sold on the e-commerce site El Shopper, which is the largest online market with more than 100 million products and more than 200,000 shops. With this case, we will also talk about e-commerce site problem later. Next slide, please. Let me start with a comparison of answers. This is question 1. The question is about administrative organization for right holders to contact in the first place. This is very simple question, but actually the most important question here. In other countries, we don't know where to go to get advice to deal with counterfeiting goods. For example, in Japan, the court or the police is taking a big role of dealing with counterfeiting, but we don't have any good administrative system for that. As we can see on the PowerPoint, in Cambodia, they have Counterfeit Committee, CCC. In Laos, they have Department of Intellectual Property. In Thailand, they have Department of Special Investigation. In Vietnam, Inspectorate of the Ministry of Science and Technology, Economic Police, Market Surveillance, People's Committee, and etc. In Japan, as I told you, it is known, but police and customs can do something. Next slide, please. This is a question about organization that support infringement decisions, especially about the initial decision maker and who supports it. For example, when the police has to decide on whether there has been infringement or not, since they don't necessarily have experts on intellectual property matters within the police. In such case, they can have some help from experts outside. That is the question all about. As we can see the PowerPoint in, for example, in Vietnam, the police and administrative organization can decide with help from assessment authorities, etc. Next slide, please. This is a question about documents to be submitted. We have answers from all panelists already, and I noticed that almost all countries are on the same page on this matter. Generally speaking, we need to submit our number 1, identification of the right holder and the infringer. Number 2, trademark registration certificates. Number 3, evidence of infringement such as samples and photos of infringing products. And plus, sometimes number 4, documents that can indicate location where the infringement happened. Next slide, please. This is about procedure from a request for investigation to remedy or relief. Under the facts of this case, from the standpoint of Company A, what procedures should be followed, and what is the average time required to complete the procedure? We also asked, are there any cases where the right holder and the infringer reached a settlement before the administrative remedy or relief? I think the panelists can explain about it later, so we can skip it here. Next slide, please. This is question number 5. This is about fines and other sanctions. The question is, what kind of sanctions will be imposed on the infringer upon a decision of infringement? Also, we asked which organization, such as police or other administrative organization, will order payment of the fine. For example, in Japan, there are no administrative penalties, only criminal penalties here. This is ordered by the court, not by the police, not by the other administrative organization, but in other ASEAN countries, we can see as a PowerPoint. So, for example, in Vietnam, they have both police and administrative agencies with authority to issue sanctioning decision or something like that. We can compare it later. So next slide, please. This is a question about burden of expenses. We have answers from all panelists and noticed that in some ASEAN countries, right holders don't have to bear any costs. But on the other hand, in some ASEAN countries, right holders have to pay the cost of chartering a truck to transport the counterfeiting goods, or the storage cost, and etc. Next slide, please. This is the final additional question. This is about e-commerce sites. Especially, we can talk about what administrative organization can do to delay counterfeiting goods on the e-commerce site. We have answers from all panelists, and I noticed that in some countries, we just needed to go to the e-commerce site or platform to delete or take down the website or account. But on the other hand, in some countries, certain administrative organization can do something. such as making a written request to the e-commerce site and so on. I think panelists can explain a little about it later. Next slide, please. Sorry, this is all from me. I would like to move on to the panel discussion now on. Now, I would like to invite our distinguished speakers. First, I would like to invite Mr. Hoshino from Japan, Attorney at Law, Patent Attorney, Japan Patent Office, to deliver his presentation.
Kuroki-san, before starting, I just want to say something.
Okay, go ahead.
May I introduce myself? Yes. My name is Masashi Kurose. I'm patent attorney and joining this symposium as a commentator. There are several ways to crack down counterfeit products. One is to filing a civil lawsuit based on the intellectual property rights in the court, and another one is to file an accusation before accusation with the police, and another one is to prevent the influx of the counterfeit from overseas with working with customs. But in addition to this, in ASEAN countries, as notable means, administrative crackdown on counterfeit products are being carried out. The investigation of counterfeit products by government agencies has been very effective in forms of speed and the investigation of counterfeit products government agencies has been very effective in terms of the speed and cost performance. So today we'd like to discuss the current situations of administrative enforcement actions against counterfeit products in ASEAN countries. Okay, let's start.
Okay, thank you so much, Mr. Kurose. I'd like to invite Mr. Hoshino again from Japan. Mr. Hoshino, you have the floor for 10 minutes.
Thank you, Mr. Kuroki. I'm Shintaro Hoshino from the Anti-Counterfeit Office of JPO. The topic is administrative enforcement action, but in conclusion, there's no administrative enforcement in Japan. The anti-counterfeit, the enforcement against counterfeit goods in Japan consists of civil lawsuit, IPR border enforcement by customs, and criminal prosecution by the police, of which civil lawsuits are the most useful. Therefore, I will explain the anti-counterfeit measures in Japan according to the case and explain the role of administrative agencies. Next, please. Now for question 1. Next, please. Sorry, next slide, please. Thank you. In case of damage caused by counterfeit goods, the right holder will consult with customs or the police, depending on the damage situation. Next, please. Question 1.1 is about administrative organization that investigate counterfeiter besides the police or the court. Next, please. Although it has no authority to detect counterfeit, the Anti-Counterfeit Office, which I belong to, provides advice on anti-counterfeit measures to right holders. Next, please. As shown in this slide, the Anti-Counterfeit Office serves as general contact point on counterfeit and pirated goods, working in cooperation with the relevant ministries and the agencies, especially customs and the consumer affairs agencies, which deal with consumer damage caused by counterfeit goods, Agency for Cultural Affairs, which has jurisdiction over the Copyright Act, and the Ministry of Justice, which organized this symposium. Next, please. Question 1.2 is about organizations which have investigate counterfeit. Next, please. Government agencies, including the Anti-Counterfeit Office, don't have the authority to expose counterfeit. Next slide, please. Question 2 is about who makes the initial decision on whether a right holder's trademark has been infringed. Next, please. The police and custom will make a decision on infringement based on the information provided by the right holder and the information obtained through investigation. And the JPO provides advice on infringement in response to inquiries from customs and the police. Next, please. Question 3 is about documents to be submitted. Next, please. The required documents are as described in this slide. The important thing is to provide documents that identify the complainant and the other party, documents that show the existence of trademark rights, and documents that show infringement of trademark rights. It would be better to submit an expert opinion or a JPO's advisory opinion. Next, please. In this case, Company B would be expected to submit at the minimum the documents as described in this slide. Next, please. For your reference, I have listed the documents to be submitted when applying for an import suspicion to customs. As time is limited, I will not express them. Next, please. In the previous slide, I referred to the JPO's advisory opinion system. In this system, the JPO gives its opinions on the scope of rights for patents, utility models, designs, and a trademark upon request. It is characterized by professionalism, neutrality, impartiality, speedy judgment, and low cost. But it is noted that it's not legally binding. Next, please. Question 4 is about the procedure for the detection of counterfeit goods. Next, please. The criminal procedure proceeds as from complaint, acceptance, start of investigation, referral to prosecutor, to prosecution by the prosecutor. Counterfeit goods are also subject to the same procedure as general criminal cases. Next, please. Judgments in criminal cases may impose confiscation as a supplementary punishment in addition to the principal punishment such as fines. Next, please. Question 4.1 and 4.2 are about settlement between right holders and infringers. Next, please. Unlike civil lawsuits, criminal cases are rarely settled by settlement. Next, please. Question 5 is about penalties. Next, please. There are no administrative penalties for the sales of counterfeit goods, only criminal penalties. Criminal penalties could include imprisonment of up to 10 years or a fine of up to 10 million yen and a fine of up to 300 million yen in the case of corporation. The sentencing is determined within its scope, with due consideration given to the maliciousness of the conduct and the reprehensibility of the motive and whether the person has a similar prior criminal record. Next, please. Question 6 is about the cost borne by the right holder. Next, please. The costs required for seizure during the investigation stage and confiscation in accordance with the judgment are borne by the police and the prosecution respectively, and not by the right holder. Next, please. Question 7 is about measure to remove items from an EC site. Next, please. Each EC site offers a right holder protection program. Right holder can use this program to apply for removal. The slide shows the website of intellectual property protection program of a famous Japanese EC site, Yahoo Japan. Next, please. Question 7.2 is about the liability of the EC site operator for damage for trademark infringement. Next, please. There is a judicial precedent that determines that not only the seller but also the EC site operator may be liable for trademark infringement if the four requirements on this slide are met. This is probably because it was judged that if these requirements are met, it can be evaluated as aiding and abetting the seller's infringement. Next, please. Question 7.3 is a way to hold the seller of counterfeit goods on the internet civilly or criminally liable. Next, please. In both cases, it is necessary to specify the name, address, etc. of the counterfeit goods seller. Criminal liability shall be pursued by filing a complaint to the investigating agency, and the civil liability is generally pursued by sending a warning letter to the seller asking them to cease the infringement before filing a lawsuit. If no response is received, a lawsuit will be filed. Next, please. One means of obtaining personal information is checking the description on the sales page of Elo Shopper. In Japan, by law, sellers who have stores on EC site must provide this information on their web page. The other means is checking the invoice by test purchase. Next, please. There are some legal means to get the identification of the infringer. Next, please. The last question is about official system to monitor the sales of counterfeit goods on EC site. Next, please. The police use cyber patrol to collect harmful and illegal information, including the sales of counterfeit goods. In many cases, trademark infringement are committed using the internet, so police try to find the clue early with cyber patrol. Okay, this is all for my presentation. Since I'm allowed about 10 minutes today, I gave a very brief explanation. Mr. Kurose, if you have any comments, please let me know.
Thank you so much for your wonderful and informative presentation, Mr. Hoshino. Mr. Kurose, do you have any comment on the presentation here?
Okay, Hoshino-san, thank you very much for your presentation. Just one comment. Japan was once criticized as a country that manufactured and exported large amounts of counterfeits to abroad. But now in Japan, there are very few cases where counterfeit products are sold in the normal markets. For Japanese companies, it is important to prevent the distribution of counterfeit imitations of Japanese products in overseas market. The Anti-Counterfeit Office within the JPO does not have the authority to crack down the counterfeit products, but it does serve as a point of contact for a Japanese company to consult. according to my experience, the person in charge at the office is very kind and polite in this question, in this consultation. I visited several times this office and asked some questions to the officers of this office, and they are very politely reported to the how to deal with these issues. Thank you very much.
Thank you, Mr. Kurose. Now, I'd like to invite the second speaker from Cambodia. From Cambodia, Ms. Som, our Deputy Prosecutor, Phnom Penh Prosecution of the First Instance. Ms. Som, thank you for joining us today. You have the floor for 10 minutes.
Thank you very much. Good afternoon from Cambodia. My name is Song Chawan. Currently, I work as a Deputy Prosecutor at the Phnom Penh Prosecution Office attached to the First Instance Court in the Kingdom of Cambodia. First and foremost, before I start my presentation, I would like to take this opportunity to express my special thanks to the Ministry of Justice Japan, ICD, and all organizer members who have put together great efforts in making this 5th symposium possible. Due to the ongoing COVID-19 pandemic, organizing such an important symposium virtually need even more hard and dedicated work to smooth the arrangement and whole process. So once again, thank you very much. The agenda for my presentation today is administrative enforcement against counterfeiting goods in Cambodia. I will briefly talk about the overview of Cambodian legal and institutional framework related to IP law. And then among many alternative administrative enforcements, such as custom, economic police, Ministry of Commerce, I will only focus my presentation on a committee, which is called Counterfeiting Committee. And in short, we will call it CCC or the committee. And then I will conclude my presentation on a simple case study to see through a procedures taken by the committee with the involvement of the prosecutors to investigate counterfeiting goods in Cambodia. So next slide, please. As I mentioned earlier, I will talk about most related law governing counterfeiting goods for this overview. Next slide, please. When dealing with counterfeiting goods in Cambodia, most related law governing those type of cases are mostly one, law concerning marks, trade names, and acts of unfair competition, 2002. We also have law on patent, utility model certificate, and industrial design, 2003. We also sometimes refers to law on copyrights and related rights, 2003. And we also have law on geographical identification, 2014, and law on detection and new plan variety, 2008. But what is interesting here when we are talking about those IP law related, we also refers to criminal procedure code, which of course provide clear rights and responsibility to the prosecutors who directly lead and supervise all type of criminal cases, including fighting against counterfeiting goods and case related in Cambodia. I will later discuss the role and responsibilities of the prosecutors in leading the investigation and decide on the search and seize of the counterfeiting goods. Next slide, please. There are many measures for the rights holders to commonly take actions against counterfeiting goods in Cambodia. Simply put, they have the choices of filing a complaint to the customs. Practically happen when those fake or falsified products, for example, are still at the border or about to cross the border. Another choice, the complaint can also be filed to economic police. For example, when counterfeiting goods are being transported from one location to another, before penetrating into the market. Next slide, please. Another common measure is to put or report those counterfeiting goods to the counterfeiting committee to take actions. And simply put, I would try to call this counterfeiting committee, in short, CCC. So who is CCC and what the CCCs generally do? CCC was established on the 31st October 2014 by a decision of the Prime Minister. CCC is led by a chairperson who is one of a Secretary of State from the Ministry of Interior, and many members composed by high officers from police, military police, custom, Ministry of Justice representative, Ministry of Health, and a few other important roles. And why it is composed of many important representatives from different ministries? Because it is task force. It is generally called the National Interagency Unit. So what is that effective about the CCC is that it has a hotline that can be reached 24 hours to file complaint of suspected counterfeiting goods. It also has a standardized complaint form that is designed to simplify and to facilitate the filing of complaint by victims. And CCC is now working on developing a cell phone application to identify the authenticity of goods and to provide chance to consumer to file any prompt complaint to CCC in case they found counterfeiting goods in their purchase. The application itself will take some time, but we are in a very good mood to that. Next slide, please. So a very simple procedure, I believe, it's happened in many countries, as I learned from the document shared by ICD, is the complaint procedures. Complaints in Cambodia is as simple as many other ASEAN countries. Everyone can file a complaint, either the victim, marks, or goods owners. So the condition or requirement of complaint is a plaintiff identification. We need letter of representation, certificate of registered goods in original country in Cambodia, or original product model. We also need information of crime and perpetrator if applicable, and counterfeiting goods product models if applicable. We most of the time also ask for analyze results to differentiate between the authentic goods and counterfeiting goods. For example, if it mostly refers to consumer products, and others to really prove that they are trafficking of counterfeiting goods. Next slide, please. So this is a general and very simple process of the investigation. Bearing in mind, Cambodia is in a civil law system, so we have the initial investigation, which mostly conducted by police officers or judicial police officer. And in those aspects, I am referring to the representative from the committee itself, who has divided into different teams. They now have up to 13 teams working together on fighting against counterfeiting goods in Cambodia. So initial investigation here is first they start to build complaint, and I already mentioned earlier those complaint requirements. And later, what it is interesting here is the start of the investigation in form of receiving complaint or report about counterfeiting goods. Usually, the investigation can take a few hours, weeks or months, depending on the complexity of the case. But one of a very effective and spontaneous examples that I can refer to myself holding the case is it takes about 4 hours to work with the victim, the rights holders, and start the investigation about 4 or 5 hours, and then we start to launch the crackdown. Other cases, of course, it takes months to really decide and get the permission from the prosecutors to start the crackdown. So if the conclusions of the investigations has already complete the requirement and forward it to the prosecutors, and the prosecutor simply agree to start the search, then the crackdown start to operate. Next slide, please. As I mentioned earlier, there are specific and standardized complaints. One of the simple ways of getting complaint is that we can either receive it by a phone calls, but most of the time phone call report is not really enough to really help investigate the case. So most of the time, and generally, we summon the plaintiffs to start taking statement and taking their opportunities to, of course, identify and differentiate authentic goods and other documents to prove their rights holders. And after cross-checking evidence, here on this stage, we usually work with Department of IP, which is under the Ministry of Commerce, to confirm the document. And usually we work with the registrars to check and cross the original certificate or the requirement certificate or documents to verify if the report or document or the evidence submitted by the right holder or the victim is really or actually acceptable and authentic. After the conclusion of the investigation, the complaint and record will be forwarded to the prosecutors to decide. Okay, the prosecutor received those evidence, cases, report, and everything, and there's a clear requirement for the prosecutors to decide whether they can start to do the searching and whether it is possible that there might be counterfeiting products at somewhere that needs to be seized. So a lot of arrangement has to be prepared in advance. Next slide, please.
Excuse me, could you a little...
すいません。
Because, yes, thank you.
So investigation here,
では、こちらの調査、この捜査がどうなっているかということですが、このサイズ、こんな形、どんな形になるのかっていうことについて確認をしていく。そして例えば店舗、あるいは特定の場所で進めていくということです。次をご覧いただきましょう。
Next slide, please. As I mentioned earlier, crackdowns. So we start to investigate, to access, and the purpose is to seize those counterfeiting goods and store it at somewhere safe. So in Cambodia, most of the cases involve arresting suspects and seize a counterfeiting good has been sent to the prosecutors. Next slide, please. Next one, please. Yes. Here, the prosecutors decides and whether the counterfeiting good has to be seized and prosecuted. Next slide, please. As I mentioned earlier, there's two options. The prosecutors decide whether this is a small petition and there's no harm, so the case can be closed without fines, or a letter of personal commitment not to commit again, or forwarded to the court. Next slide, please. Next one, please. Yes, this is a case study. Actually, tons of fortified medicine has been seized during the crackdowns, and it has a lot of victims, and it impacts a lot of health problem in Cambodia. Next slide, please. One of these case study, we found more than 2 tons of different medicine has been packed, has been stored under fortified conditions, not under rice conditions, and the total confiscation of those fortified medicine is more than 100 different medicines. Next slide, please. This is a list of medicines that have been confiscated, and the case has now forwarded to the court. So the conclusion of the procedure is very simple. Primary investigations, and conclusion of the investigation to search and seize, crackdown. So people have to be questioned. This is the very simple procedures. There are many procedures for rights holder to commonly take actions against counterfeiting goods. Simply put, a complaint start, and then it can end up into a prosecution or the court. That's the end for my presentations. And before that, I just want to have a few words for this presentation. As the pandemic continues to impact families, healthcare services, communities, and economy worldwide, criminal continues to exploit the crisis for financial gain. And therefore, end-user victims of fake and/or fortified products, especially medicine, need more attention, especially in Cambodia. One way to help them is to simplify the process to their complaint by taking a quick and spontaneous action against counterfeiting goods trafficking into the market. And because of that, the committee itself has been doing their work quite effectively recently and for the last 5-6 years. And that concludes my presentation. Thank you very much.
Thank you so much for your presentation, Ms. Song. It was so meaningful for us. Mr. Krause, do you have any comment on the presentation here?
So, Son-san. Thank you very much for your presentation. I just introduced the an important role in the investigation of counterfeit products in Cambodia. Right holders they do not have to file a complaint directly with the police, but by applying to the CCC, the right holder can quickly take actions against counterfeit products. You skipped the important slide 12, but they explained that in the case of a small amount of infringement goods, prosecutors will not be made. Prosecution will not be made in Cambodia. It's a small amount of infringed goods. However, if the infringement is repeated, it will be punished. That's okay? Right?
Yes, that's right.
The CCC does not directly carry out the raid or seize actions, but the police will seize infringing products unless infringers, according to the instructions of the prosecution's office. Only one question just. Who will bear the cost of the seizure process? For example, the cost of transportation of seized counterfeit, the cost of storing counterfeit goods, and the cost of disposing counterfeit goods. Do all of these costs have to be borne by the right holder who applied for the investigation or seizure?
Thank you for the questions. Because this is a criminal case and referring to the burden of expenses will rely upon the state. So either in the seizing and storing, transporting of counterfeiting goods after the crackdown, the expenses will be bound by the government or the state. But later, if the court found guilty of the infringement, all the burden of expenses will be all their responsibility.
Okay, thank you very much.
Okay, thank you so much. So I'd like to invite the third speaker from Laos, Ms. Somonik, our Acting Director, IP Dispute Resolution Division, Department of Intellectual Property, Minister of the Industry and Commerce. Ms. Lina, you have the floor for 10 minutes.
Thank you for a very nice introductions for me. And dear all the participants, and dear Mr. Kuroki and Mr. Kuroche. So First of all, I would like to thank you for this opportunity to invite me to be the speaker here. Even though it's during the COVID-19 pandemic, but we still have the useful forums, and we should thank you for the technology that we are here. And before I start my presentation, and I just would like to brief about my introductions about the IP. So you can go to the next slide, please. So my content today, I will talk about the IP administrative organizations and the legal frameworks and the IP the specific facts. And the last one is the administrative enforcement against counterfeit goods. Next slide, please. So the DIP and IP activities allows consider an important elements of the law government's policy, and so that the intellectual property system we established in 1990. The DIP is an administrative organization is responsible for the IP legislation for the industrial properties, new plant varieties, and copyright and related rights throughout the country. In the central administrative organizations, the DIP is under the Ministries of Industries and the Commerce. In the provinces, we have the Office of Industries and the Commerce to handle the IP applications and infringement cases that occur in the provinces. So the next slide, please. So the role of and the duties of the DIP we are to study the IP policy, strategies and the law relating to the IP activity, and drafting the law and regulations, instructions, recommendations, guidelines, and implementations of the IP by means of legislations and providing the IP service, and providing the administrative disputes resolutions, and disseminations and organizations of the public IP awareness, and coordinate with the relevant sectors in the fields of intellectual property. And also the cooperation with the international organizations in the fields of the intellectual property too. And the next slide, please. Next slide, please. So for the legal frameworks, we have the IP law. First, the editions we have in the year 2007. And the second editions we have in the year 2011, and the third one is in the year 2017. The purpose of the establish the IP law in the year 2007 to cover the frameworks of the protections and the administrations of the industrial property rights, new plant varieties, and copyrights and related rights. And the second editions in the year 2011 to revise and update the laws on intellectual properties in the year 2007 to bring it into the compliance with the WIPO's and the TRIPS standard to become the WTO's member. And the third editions in the year 2017 to replace the laws on intellectual property in the year 2011. In this, we extended the frameworks of the trademarks protection to cover the 3D image and the movements image, allowing the oppositions of the industrial property. Many of the provisions focus on the certain requirements as law is interest to joining the UPOP. The new law also simplify the ground which criminals offense may be initiated. The next, please. Since the IP activity we established in 1990, at that time, we started to receive only the trademark applications, and in the year 2004, we started to receive the patents and industrial designs. In the year 2009, we just received to copyrights and related right notification, and in the year 2019, we received the new plant varieties application. That's new one for us in the fields of the IP. Next slide, please. For the IP specific facts, recently we have registrations of the patents, industrial designs in the fields of the trademarks, including the trademarks under the metric systems, geographical indications, and new plant varieties and notifications of the copyrights and related rights. But we don't have the big numbers of the application for the patent filing. Most of them from the overseas, that including the PCT's applications, the same as the trademark application, the 90% of the applications are from overseas and non-residents in Laos. Only the small numbers of domestic applications for the trademark registrations. And for the GIs, we have already registered the 7 GIs, 6 of them. It's Lao GIs and only 1 GI is from overseas. And the others IP such as their trade secrets and their trade names, there is no requirement to be registered, but shall be protected under the IP law. The next slide, please. For the institutional arrangements, of course, the DIP is and the organization as administrative organization. Of course, we have the one director and 2 deputy director general, and we consist of the 8 divisions and 1 IP service center. As patents divisions is responsible for the patents applications, such as formality examination, not conduct the substantive examinations for the patents, but the applicants can submit the international search reports or the certificates granted for the such inventions from the other country before filing the application to Laos. And in the fields of the trademarks and industrial design applications, we have done formality and substantive examinations in order to fulfill for the requirements for registrations in fulfill of the requirements for the registration. And in the fields of the copyrights, not any requirement for any formality examination. It is voluntary system. The copyright owners may or may not notify the copyright works, but there will be automatic protections under the law. And divisions of the IP dispute resolutions dealing with the disputes relating to the IP registrations, such as oppositions, refusals, and cancellations of the IP registration. The next slide, please. Next slide, please. So for the viable option for the IP dispute resolutions, we have the reconciliations, mediations, administrative remedy, and the remedy through the Economic Disputes Resolutions Committee. And the rights holder can file their judicial action to the People's Court for the judgments and international disputes settlement. The IPS and administrative organizations have the significant roles in the dealings with the administrative remedy relating to registrations of industrial properties, new plant varieties, and copyrights and related rights. Next slide, please. So in the case of the trademarks infringements and the counterfeit goods, in the common routes for the rights holders may contact the IP to get their initial decisions or the legal advice, or identifies issues on the trademarks infringements or the counterfeit goods before the proceeding the legal actions against the infringer. And the others, the rights holder can file the letters of the complaints and request the administrative dispute resolutions under the procedures of the DIP if they have the sufficient information about the infringer who infringing their rights. The same as a similar case, if the rights holders found the trademarks or use the marks that's the same or the similar with the owner of the trademark, they would file the application to the DIP in order to get the legal advice, the same procedures as the infringements. And beside the police and the courts, the administrative organization to investigations, including the seizures of the counterfeits in practice, the rights holders can contact the trade authorities or the inspectorate committee. They also have the significant role in inspecting the goods, protecting the rights of the consumers, including the counterfeit, the trademarks, and infringements of the industrial designs and the pirated copyright goods. Next slide, please. Next slide, please. And the documents when the rights holders file the application for the IP disputes resolution, at least they have to submit the copies of the certificate of the trademarks. And if the rights holder is in foreign country, they have to file the application through the IP representatives. We need the powers of the attorney in the case of the filing through the IP representatives. And also the examples of the genuine and the fake goods, or can be the clearance of the photos of genuine and the fake one. And the other supplementary information or the evidence in supporting the claims of further legal proceedings against the infringer. Next slide, please. For the IP disputes settlement, the rights holders can arrange the settlements, concludes their disputes via the reconciliations or the private mediations via the legal professional. Is more the effective. Another case, they can file the application to the DIP for the mediations between the IP rights owner and the infringer under the supervision of the DIP, and also the rights holder can file the application or the complaints to the IP Economic Disputes Resolutions Committee. It's also done with through the arbitrations and mediations. Next slide, please.
Sorry to interrupt. Could you a little repeat, please? Sorry.
Okay. For the counterfeits in online platforms, in these issues, we don't have much information to share with you, but it's really the big issue for us in Laos right now. But in general practice, if the rights holders can file the complaint to the IP, we just give their advice or the opinions that they can do or where they can go to implement their right. If they have the sufficient evidence information, they would contact economics, police, or internet service provider together with sending the warnings letter to internet provider. That is viable option that the right holder can start the legal action. The next slide, please. For the fines and the sanctions and the burdens of the expenses, it's just for the reference, but in the administrative IP resolutions, we don't have fine any damages of the values. This just for reference. If the first time violators or damages of the infringements are the small, we just educate or the warning measures will be applied. If the second time offenders, a small fine will be imposed, and which is not the criminals, we just fine the 1% of the damages of the values occur. And another, if intentional violations for the second times and repeated times, the 5% of damages values occurs for each violations. If more serious case, it's more serious case, it can be the punished by the imprisonment or the fines, depends on the nature or the serious offense. So that's all information that I can share with you. Thank you.
Thank you so much for your wonderful presentation, Ms. Rina. Mr. Kurose, do you have any comment on that?
Okaoka-kun, Sunya-san, thank you very much. There is no special administrative agency in Laos to deal with counterfeit products. However, as you said, the right holder can consult with the DIP before applying with police. Because submitting the official opinion from your DIP is very effective to take actions very quickly and reliably by the police. Is that right?
Yes, because the right holder can go to the police, economics police or the custom in the case of the border infringements.
Okay.
But when the rights holder go to the police, they still need some official document, right, certify that is it infringements or not, or it's kinds of the similar cases. Sometimes they need to the documents, official documents certified by the DIP, and then they proceed the legals against the infringement.
Okay, thank you very much.
Thank you so much. I'd like to invite next speaker from Thailand, Ms. Ruwen Groom, Legal Officer, Senior Professional Level, Department of Intellectual Property, Ministry of Commerce. Ms. Ruwen Groom, you have the floor for 10 minutes.
Thank you, Mr. Kuroki. Okay, good afternoon, everybody. First of all, I would like to express my gratitude to the Ministry of Justice of Japan to invite me to be a speaker in the symposium. Okay, let me start with the talk with the IP roadmap in Thailand. Next, please. Okay, the Royal Thai government placed a high priority on combating piracy and counterfeiting with integrated collaboration of relevant agencies to expand the sale of IPR infringing products on both physical and online market. To lay down a comprehensive policy guidance on IP protection and enforcement, the National Committee on IP policy chaired by the Prime Minister and consists of 18 the head of government agency approved a 20 years IP roadmap which reform the country entire IP system in the line of in line with the Thailand 4.0 policy. The IP roadmap consists of 6 areas, 4 of which are under the intellectual property value chain, namely first IP creation, second IP protection, third IP commercialization, and fourth IP enforcement. The other 2 areas involve community intellectual property and nation intellectual property, namely geographical indication, genetic resources, traditional knowledge, and traditional cultural expression. Next slide, please. Let's move to the IP enforcement policy in Thailand. The National Committee on IP Policy appointed a subcommittee on IPR enforcement chaired by Deputy Prime Minister, who is the responsible for security and crime suppression matters and consists of 11 heads of enforcement agency. The subcommittee play a major role in determining measure and overseeing all enforcement operation in Thailand to effectively eradicate IP infringement. The subcommittee on IPR enforcement has appointed 3 working groups. First is the working group on suppression of IP violations. Second, working group on suppression of IP over the internet. Third, working group on destruction of IPR infringing goods. The 3 working groups composed of all related government agencies such as police, office of anti-laundering money, custom department or department of special investigation. This working group shared by Internal Security Command and the DIP is the part of the Secretariat. I think it's all about the structure of IP enforcement policy in Thailand. Next, please. Okay, let me move to the enforcement in the physical market. Despite the COVID-19 outbreak, enforcement agencies have consistently monitored in the shopping area with a history of counterfeiting and piracy. Notably, the pandemic have rendered such civilian shopping area and market inoperable. Moreover, market surveillance conducted by the DIP police, the Royal Thai Police, and the IP right holder has not identified activity in most areas and market during the COVID-19 period. Next, please. I will show you the sample case in 2021 in 19 January. I think it is a big case during the COVID-19. The DIP in cooperation with the economic police and IP owner execute a search warrant issued by the court in Ban Mo area in Bangkok. Almost 38,000 infringing items such as portable radio products and their supply. I think the antenna, and battery charger and battery for the mobile. The worth more than 50 million baht. Next, please. Okay, let me talk with the enforcement against online intellectual property right. Now, in Thailand, the IP infringing activity has shifted from physical to online market, which categorized as follow. The sale of IPR infringing product through online channel, namely first e-commerce platform, second social media platform, and third infringing website. The most is the private website. The measure of enforcement against online IPR infringement are notice and take down, website blocking, and criminal enforcement. Next, please. As the enforcement of law may not entirely resolve the challenge of online IP infringement, the establishment of the cooperative mechanism between the government agency, IPR owner, and internet platform operator to suppress online IPR infringement are important. The Department of Intellectual Property as the government office responsible for the IP-related matters in Thailand has initiated the MOU on the protection of intellectual property rights on the internet. This MOU does not create an additional right for the IP owner, but acts as a mechanism to gather all the relevant stakeholders to address issues related to online IP infringing in a unified and mutually agreeable manner. The signatory of the MOU fall into three categories. First, the government authority, including the Department of Intellectual Property, Department of Business Development, and Department of International of Trade Promotion. That's all the department is under the Ministry of Commerce. The second is the e-commerce platform operator, including Lazada, Shopee, and JD Centan. They are the most popular platform in Thailand. Third is the IP right holder, particularly the trademark owner facing ongoing counterfeiting problem in Thailand. Next, please, let me talk with the cooperation, scope of the cooperation under the MOU. Three means to initiate the process as follows. It starts with the IP receive the report by telephone, email, or any other channel, and conduct initial search before notifying IPR owner. And then when IPR owner or the law firm explore and examine the fact and report directly to the internet platform operator, e-commerce platform in Thailand with the link of the sale and image of IPR infringing products. And then the internet platform operator establish a channel for receiving the report and remove the IPR infringing goods. Next, please. Next is the IP enforcement activity or awareness in Thailand. On the slide, we list the campaign Go for Real in cooperation with the U.S. Embassy in Bangkok against online piracy. All this campaign aim to create a video clip against the online piracy and in the physical also. And all the participation on this campaign is students from the school and the university. Next is the destruction ceremony of IPR infringing goods. the Department of Intellectual Property in collaboration with the Internal Security Operation Command, the Royal Thai Police, the Thai Custom Department, the Department of Special Investigation, and RPR owner organize a ceremony on a yearly basis. Due to the COVID-19 in 2021, the destruction ceremony took place at the Ministry of Commerce with actual destruction being live streamed from the destruction site in Salaburi province and Chonburi province. The destruction ceremony was witnessed by several groups of stakeholders from public and private sector, including the foreign agency. I think it is all about combating of the IP infringing in Thailand. Thank you.
Thank you, Ms. Luen Grun. It was a wonderful presentation here. Mr. Crosse, do you have any comment on that?
Thank you very much. According to your explanation, we understand that the DIP plays a very important role in the suppression of counterfeit products in Thailand. When a counterfeit product is found, the right holder can apply to the DIP for investigation. The DIP will work with police to seize the counterfeit products. In addition, the DIP can appraise whether or not the products are actual infringing products. So if I have more time, I'd like to ask the e-commerce issues, but there is no time, so please proceed to the next.
Okay, thank you so much for your comment. I'd like to move on to the last speaker here from Vietnam, Dr. Nguyen, Deputy Chief Inspector, Ministry of Science and Technology. Dr. Nguyen, you have the floor for 10 minutes. I think your mic is muted. All right.
Okay, it's okay now?
Yeah, I can hear you clearly.
Okay. And I have only 10 minutes, right?
Yes, it is.
Okay. Okay. So I would like to say thank you to the Ministry of Justice of Japan for inviting me to join this symposium. And also would like to say thanks to the other speakers to share their experience and information relating to IPR enforcement in different countries. And the forum today is for administrative enforcement against counterfeit goods. And so actually, you have the case study, and we also already sent the answer to the organizer. And in Vietnam, the IPR infringement, I mean online IPR infringement, is also a big issue, like everywhere in the world, and the government pay very special attention to the issue of infringement, online infringement, by making the new policies and laws for the issue to deal with the issue. And now we are working with amending the IP laws, and the issue of IP online IPR infringement also putting in the new amendment. I mean the amendment of IP law in Vietnam. And now I just want to go straight to the subject of the today symposium. That asking by the organizer, that is administrative measures against counterfeited goods in Vietnam. Okay, well, in Vietnam we have 4 different measures for IPR holders to take action against counterfeited goods. We have okay, next slide, please. Sorry. And provided by laws that we have 4 measures: civil, criminal, administrative, and borders. and belong to two different state system, that is administrative agencies and judicial agencies. And with judicial agency, they are working with civil and criminal measures. And I would like to share with you about the official statistic in Vietnam, that nowadays around 90% IPR infringement case handled by administrative measures. So administrative measures is the most important actually measures in Vietnam to fight against IPR infringement. Okay, next slide, please. And provided by Vietnamese laws that the administrative measures applying to the case that appear already on the slide that all of you may see now. Actually, the administrative measures applying to the infringement, including the producing, importing, transporting, and trading in IP counterfeit goods, or assigning others to do so. And actually, there is a borderline between administrative and criminal sanction for IPR infringement. And now in the Penal Code of Vietnam, provided very clearly that a case, IPR infringement may be imposed by criminal sanction if is appear three sides. First, that is the illegal profit that infringer earned is from around 4,000 US dollars. And the second one is the losses or damage to the owner, and is around 12,000 US dollars. And the next one is that the violating goods value and is from 8,000 US dollars and can be submitted to police or court for criminal sanction. And that is the borderline between administrative and criminal measures. Okay, next one, please. Okay, and about the competence, as mentioned at the beginning, that in Vietnam there are many different agencies have the authority to work with administrative measures. The first one, that is the Ministry of Science and Technology. That is our department and inspectorate, and we handle the infringement for industrial property rights, and we are the authority, the unique authority that have the function to fight against the infringement, like patents infringement, industrial design, unfair competition, and now it's a trade name and domain names, and especially statistic showing that now the case relating to trade name, domain name, and secretary and patents is increasing gradually in Vietnam now. Okay, next one, please. And beside the Inspectorate of Ministry of Science and Technology, provided by laws that we have a Ministry of Culture, Sport and Tourism, and they have the function to deal with copyright and related rights, and also Inspectorate of Ministry of Information and Communication. And relating to this area, the Inspectorate of Ministry of Information and Communication only working with unfair competition relating to domain names. Okay, next slide. Next one, please. Okay. And market surveillance agency. You know, market surveillance agency is a very important authority in Vietnam. Have the authority to work with IPR infringement, and they have the function to deal with the trademark graphical indication, industrial design, and accept patents, like Ministry of Science and Technology. I mean, Inspectorate now working with. And the other things is that market surveillance usually, in principle, they have only rights. The only authority to work with the infringement is available on the market. I mean, it's in trading and transporting, and not in manufacturing. Yeah. And they have only rights to working with the IPR infringement in, I mean, manufacturing infringers, if they detect the infringement through detecting the case in trading and transporting. Okay, next one, please. Thank you. And then we also have the economic police, have the authority to work with IPR infringement, with the right to detect, verify, and collect information and evidence of infringement case. Okay, next one. Okay, and we also have the right provided by laws for provincial and districts pupils committees working with IPR infringement at the local level. Next one, please. Yeah, okay. And before going a little bit to major penalties, I would like to express that, like the other countries in Asia, or in very developed countries like in Japan or in the US, we also have the agency coordinating the other the different agency to cope with IPR infringement. And in Vietnam, we have two most important play the roles in coping with IPR infringement. I mean, coordination programs and agency. The first one is the National Steering Committee fighting against commercial fraud and importings. I mean, the illegal importings. That is 3H9 office, if some of you may know. And the second one, that is program 16H program, the coordination program among 9 ministries that preventing and fighting against IPR infringement. I mean, the second program only focus on counterfeited goods, and Ministry of Science and Technology is the standing agency for this program, and I am the head of standing committee. Okay, that is a very focused on IPR infringement. Okay, and the major penalties, you may know already that we have warnings and fines, and the monetary fines for organization is a little bit different for the individuals, and the maximum fine for infringing organization is around $23,000 US, and for individuals is around more than $11,000 US. And next one, please. And besides that, we have a supplementary penalties. It's like a confiscation and suspension of business activities. I think it's the same many countries in the world. Okay, next one, please. And we also have the other remedial measures like possible destruction and possible bringing out of Vietnamese territory for Chinese good infringing upon industrial property rights. Okay, and that is remedial measures. Next one. And besides that, we also applying the different preventive measures to secure enforcement of administrative penalties. Okay, so I would like to say that in Vietnam, the legal infrastructures for IPR infringement was set up quite early. I think it's around 1980s. And we issued the first law on IP laws in 2005, and now we are in processing for the third term of amendments with the new provision for the the global direction. Okay, and also the government in general and the Ministry of Science and Technology, the agency managing IP issue in Vietnam, pay very special attention to the IP issue in general and IPR enforcement in particular. And we work very closer to different countries like I think Japan and US and the US and EU and of course Asian countries to improve the effectiveness of IPR enforcement in Vietnam, and very happy to work with all of you and hope that we will see each other somewhere in the world when pandemic is already going down. Thank you so much, and wish you all happy and healthy and successful. Thank you.
Thank you so much for your wonderful and informative presentation here. Mr. Croce, do you want to have any comment here?
Yes, thank you.
Oh, thank you so much. Wonderful.
Yeah. As explained, in Vietnam, the government agencies are very actively combating counterfeit products, especially MOST. MOSTO is very doing very important role. Okay, and government agencies can seize counterfeit products at their own discretion without the need for police assistance. Government agencies also have the authority to punish manufacturers and sellers of counterfeit products at their own discretion. And also, you did not introduce, but in Vietnam, there is a public appraisal agency, so-called BIPRI, B-I-P-R-I, IP Research Institute, which can request appraisal for cases where it is difficult to judge infringement. It's very useful, I think. So I have many questions in Vietnam, but time is over now. Please, next time I want to ask you. Thank you.
Thank you so much. Yeah, we will have a Q&A session later, so we can have more discussion over there. So thank you so much for your wonderful discussion and presentation here. We have reached the end of working session 1. We also have another working session 2 and Q&A session later. We would like to welcome you again if you are available. So we will take a break for 10 minutes.